Shri Guru Namaha children. Welcome to our online teaching academy. Today we are going to see the lesson joint stock company. First we are going to see the definition. According to Lord Justice Levy of England has defined joint stock company as an association of many persons who contribute money or money's worth to a common stock and employ it for a common purpose. See, the joint stock company in India are governed by the Companies Act 2013, but the new act has been divided into 29 chapters with 470 sections. Okay, this joint stock company is distinct type of business organization. How it listens, the advancement in science and technology and the impact of the industrial revolution have all necessitated a large amount of capital investment and highly sophisticated managerial skills for running a large scale industries. So the partnership and the sole trader have limitations of capital and managerial ability, isn't it? They add risk of unlimited liability has been found, unsuitability for running a large scale industries in modern times. Okay, so that the joint stock company form of organization came into existence. Okay, a company is an artificial person created by law having a separate entity with a perpetual succession and a common seat. Section 2 of Companies Act 2013. What a company is saying, no? So, if a company is a group of person, artificial person, is joining together and starting some business. It has a perpetual succession. Perpetual succession reasons continuity of life. And each and every company is having a common seat, separate seat. The section 2 of Companies Act 2013 is saying like that. Now we are going to see the characteristics of joint stock company. So first, separate legal entity. Separate legal entity. So under incorporation, company becomes a separate legal entity. As compared to its members, the company is distinct and different from its members because the entity will be in somewhere else and then the management will be in somewhere else. The company is distinct and different from its members. Okay, so it has its own seal and own name. It assets and liabilities are separate and distinct from those of its members. It is capable of owning property, incurring debt, and borrowing money. Employing people, have a bank account, entering into contract and suing and being sued separately, and then it is considered as an artificial person created by law. So through the company's law only we have to follow, and then in Companies Act 2013 we should follow, and if you want to open the company. Limited liability. So in sole trader and partnership and all, we saw it is unlimited liability. Here the liability of each to contribution to the assets of the company up to the face value of share held by him. The member is liable to pay another liable to pay only the uncalled money due on shares held by him. So how much he bought the shares, that much only he is going to pay the amount. Okay. More than that, the company will not disturb the members. If the asset of the companies are not sufficient to pay liability, the personal property of the shareholder are not held reasonable, not responsible. Okay. And then paternity succession. See, it is not a perpetual succession. Okay, so perpetual succession in the sense continuity of life. Okay, perpetual succession, which means a continuity of life. A company does not cease to exist unless it is specifically moved up on the task for which it was formed has been completed. Membership of the company may keep on changing from time to time, but that does not affect the life of the company. The company is created by law and it can be bind up only through legal process. And then numbers of members. So the minimum private limited company in the sense minimum uh, uh, minimum people should be there. Okay, so for example, if it is a public limited company, in the sense minimum seven should be there and maximum it is limitless. But if it is a private limited company, in the sense minimum two members should be there, maximum 200 they have mentioned. Okay, so before and all it was 50 only. Now they have changed to 200. Okay, the members. And then separation of ownership and management. So management will be in somewhere else, and then the ownership will be in somewhere else. Okay, so the company is then administered and managed by the managerial personnel. The board of directors only will run the business. So the shareholder are simply the holders of the share in the company and need not necessarily the managers of the company. They will not do any business in that. They will only contribute. That's all. They will definitely they will never do any business in that company. Okay, they will never enter day-to-day works. Okay, and then advantages of joint stock company. Already I said so many advantages we are having. Limited liability first. The liability of the shareholder is limited. Already I said. In the case of the company, limited by guarantee, his liability is restricted to the amount that he has guaranteed to contribute in the event of winding up of the company. And then large scale operation. You know that the company is a large scale operation only. The company can secure large capital compared to sole trader and partnership. Large amount of capital is necessary for conducting the business on the large scale. For example, Reliance has invested more than 25,000 crores in the telecom venture. Raising such huge amount of funds would be utter imposed in a sole proprietorship or partnership. Transferability of shares. Transaction of shares between two individuals is easy. So there is liquidity of the investment. Any shareholder can easily convert his share into money by selling his shares. Anytime you can buy or sell your shares. Perpetual succession. A company has perpetual or continuous existence. Members may come or go. New members can come, but the company continues to exist. This ensures continuously in operation and the company can undertake long-term investment. Risk-bearing capacity. The loss of the company is distributed over a large number of shareholders. So each shareholder bears very little amount of loss. Hence, a company form of organization has risk-bearing capacity. Disadvantages of joint stock company. So far, we saw advantages. So many advantages we are having also. We have some disadvantages. Costly and difficulty to form. So the number of legal formalities are much observed in the formation of the company. To observe these legal formalities, promoters have to spend much time and money. Lack of interest. So if you are not having any interest, you cannot continue the business. The officers of the company do not have incentives to work hard. They are not usually inclined to take risks. So they lack initiatives. Lack of good labor relationship. The sole trading a business personal supervision is possible, isn't it? So, but in company form of organization, there is a lack of personal contact between the owner and the worker. As a result, there is a scope of more industrial disputes in the company form of organization. Speculation. A few individuals may corner the shares to gain control over the company. High taxation. Joint stock companies have to pay tax at high rates compared to other form of organization because it is a huge organization. They are investing more capital. That's why they have to pay more tax. And then next we are going to see the types of companies. Classification of companies on the basis of incorporation, on the basis of membership, on the basis of liability, on the basis of control, and then on the basis of nationality we are going to see. See, this is the classification of companies, children. First, on the basis of incorporation, we have chartered companies, statutory companies, association, not for profit. And then membership, we have public and private. And then members liability, we have limited by shares, limited by guarantee, limited liability. And then control, government company, holding and subsidiary company. And then nationality, domestic company, foreign company, and multinational company. Next, we are going to see the articles of association. This is very much important, children. You have to learn this. Okay. So, articles of association means it is a document that contains the purpose of the company as well as the duties and responsibilities of its members. It is an important document which need to be filed with the register of the company. Before starting the company, you have to fill all those things. Then only you can start the business. We have some contents also is there in articles of association. The amount of share, capital, value, type of shares, and then rules regarding issue of shares and debentures, manners of transfer of shares, declaration of dividend, and then borrowing powers of the company, everything they have mentioned in the articles of association. That is the content of the articles of association. Next, we are going to see the memorandum of association. Memorandum of association is a legal document prepared in the formation of the registered process of the limited liability company to define its relationship with the shareholders. It reveals the power it has and wants activities the company is permitted to undertake. It is the public document and any person dealing with the company is presumed to have sufficient knowledge of it. It is the primary document of the company. So this is a very important document of the company. How you are going to start the business, what are all you are going to do in that business, everything they have mentioned clearly. Okay, and then this it is the constitutions of the company in its relationship of the outside world. So it is a public document and any person dealing with the company is presumed to sufficiently knowledge of it. It is the primary document of the company. In this memorandum of association, we have so many contents. In that, name class, situation class, objective class, liability class, capital class, and then association class. Okay. So first we are going to see the name class. Name class in the sense, what is the name you are going to keep for the company? The name class requires the stated legal and recognized name of the company. The company name is allowed to be registered if it does not bear any similarities with the name of the existing company. So, company is one. Situation class. The register office class requires to show the physical location of the register office of the company. It is required to keep all the company registers in this office. The register office should be established prior to commencing business activities. So, where it is situated, that is very important. Objective class. What business you are going to do in that company? Okay. The objective class requires to summarize the main objectives for establishing the company with reference to the requirements of first shareholding, the use of the financial resources is required to state an ancillary objective, that is, those objectives that are required to facilitate an achievement of the main objective. The objective should be free of any provision or declaration that contravenes law of public good. And then liability class. The liability class requires the state of extent of which shareholder of the company or liable to the obligation of the company in the event of the company dissolving. There are companies limited by and then capital class. The capital class requires to state the company's authorized share capital, how much they are going to invest, the different categories of shares, and then nominal value, and then how many shares you are going to sell, or how many types of shares you are going to sell. It is also required to the list of companies' assets under this class. And then association class. The association class confirms that shareholders bound by a memorandum of association are willingly associating and forming a company. It has required 7 members to sign an MOA. I said no, in public limited company in the sense minimum 7 members should be there. If it's a private limited company in the sense 2 members should be there. They have to sign in the document of the MOA. The signing must be done in the presence of witness who must also append his signature. So, and then next we are going to see the prospectus. According to section 236 of the Companies Act, any document inviting the public to buy shares or debentures comes under the definition of prospectus. This also applies to advertisement inviting deposit from the public. So prospectus is an invitation to invite the public to buy the shares. So, okay, so it is very much important to if public limited company only can issue the share. They have only have rights to issue the shares, not a private limited companies. Okay, we understand, children.